Good afternoon, Chief.
Good afternoon, Andrew.
Thank you for granting this interview. I believe this is your last interview before you retire on the 26th.
Yes, I think it's the last.
Chief, first of all, many Filipinos, including Justice Marvic Leonen during our CNN interview, and also former Ombudsman Conchita Carpio Morales, describe you as the best Chief Justice the country never had. How do you feel about that?
Well, again, as a constitutionalist, the appointment of a Chief Justice or any Justice of the Supreme Court is a prerogative of the President, and that's in the Constitution, so I respect that. I think they're just saying that because they feel that I should have been there, but under the Constitution, it's the President who appoints.
As sir, last Friday, former Chief Justice Artemio Panganiban, he announced that you declined to have the traditional majestic way of honoring justices. Instead, you prefer a simple dinner. Why is it?
Well, I think it's more in harmony with my character. I mean, I've been through all of these retirement ceremonies for the last 18 years, and some also chose to have a simple ceremony, just a dinner, and I think that would be fine with me. That's enough for me.
Justice, you wrote 935 full-blown decisions and 79 dissenting opinions in your 18 years in the judiciary. Is there a particular case close to your heart, or would you consider a landmark case?
Well, yes, the Lambina versus Comelec case, because it involved the constitutionality of the People's Initiative, and had it prospered, we would have taken another turn. I mean, we could be a parliamentary system by now. So I think that was a very important case, because that decided whether we should stay under a presidential system or transform into parliamentary by just a people's initiative, because the people's initiative was not really meant to drastically revise the Constitution. It's just to amend certain parts of the Constitution, but not change the structure.
Chief, in your dissenting opinion in the Marcos electoral protest case, you said, and I quote, "The last thing the tribunal should do is to change its rules in midstream to accommodate a party who has failed to comply with what Rule 65 of the 2010 PET rules expressly requires." Is the tribunal changing the rules, and why?
Well, they have not yet, because they said, we want to listen. We want the comments of the parties. But for me, you don't even have to ask for comments, because the rules are clear.
Sir, let's go to your advocacy, the West Philippine Sea. Sir, what is the strategy of the government on the West Philippine Sea, and is it working?
Well, for me, it's not, we are not optimizing our victory, our victory at The Hague. I think we can do more, because when the ruling came out, almost the entire world was with us. The European countries, the North American countries, the US, Canada, Japan, India, Australia, New Zealand, they were all for us. And they were pushing us to assert the ruling, but the government decided for a soft landing. They called it a soft landing. I think we lost a lot of time there, but it's we can still recover, I believe. The ruling is still intact, and I think there's a light at the end of the tunnel now, because the other countries in ASEAN, who are also prejudiced by China's 9-dash line, have resisted the Chinese claim because of the ruling. Because the ruling says the 9-dash lines have no legal effect, cannot be used to claim any part of the waters of the South China Sea. So that has stiffened their back, and that's why Vietnam is very forceful in defending their maritime zones. And I think that's why China now has agreed to sign the MOU, the TOR, on Reed Bank. I see this as the light at the end of the tunnel, because if we can come to an agreement on this, if we can implement the agreement, then that would be a template for a South China Sea-wide solution to the dispute, because under those terms, I think Vietnam will also enter into such an agreement with China. So will Malaysia, and probably Brunei also, and even Indonesia. Because under the MOU and the TOR, we preserve our sovereign rights over our EEZ, and that's what's important to the coastal states. And of course, we also allow China to lift the oil the same way that Shell is lifting the gas now, lift the gas, and they'll be paid for it, just like the way we pay Shell. That's part of a commercial agreement. That's the danger of the Code of Conduct. It could legitimize the air and naval bases of China in the Spratlys and in the Scarborough Shoal if they sign after they have built there.
And sir, what is the value of a code of conduct now that China seems to have completed its takeover and reconstruction of features in the South China Sea?
China has not completed its island building because they have not started island building in Scarborough Shoal. I think their last air and naval base that they will put up in the South China Sea, in the disputed area, is Scarborough Shoal. Because all the other islands that they seized in the Spratlys, in the Paracels, they put up air and naval bases. So why will they exclude Scarborough Shoal? And they need to put an air and naval base in Scarborough Shoal because there is a hole in their radar and missile fighter jet coverage of the South China Sea, because they have in Woody Island in the Paracels, they have in Spratlys, but they don't have in the northeast area. And when President Obama was about to leave office, Beijing sent dredging vessels to Scarborough Shoal, and Obama called up President Xi Jinping. You cannot do that. That's a red line, and the Chinese dredging vessels returned. Of course, that was also just before the G20 meeting in China, and I think President Xi Jinping didn't want to mar that meeting with an incident. So it shows the plan of China. They have that plan, and of course, they will resurrect that plan sometime in the future. So what will a code of conduct do to that? If China today will sign a code of conduct without building on Scarborough Shoal, that would be great, because then they cannot build on Scarborough Shoal. But I think they will sign a code of conduct after they finish their reclamation, after they have built an air and naval base in Scarborough Shoal. And once they've done that, they will tell everybody, let's sign this code of conduct. Nobody builds anything anymore. And that will legitimize everything that they built. And I think that's the danger of the code of conduct. It could legitimize the air and naval bases of China in the Spratlys and in the Scarborough Shoal if they sign after they have built there.
So, sir, claimant country should prevent that from happening.
Yes,
before signing a code of conduct.
Yes, we should tell China, we will not sign a code of conduct if that's your game plan, because that will only legitimize what you've been doing now. If we have to say that there should be no island building, the recording date should be 2002, when the Declaration of Conduct was signed. In 2002, everybody agreed, China and ASEAN agreed, no more island building on islands that were uninhabited in 2002. In 2002, China has not built anything on Scarborough Shoal. They have not seized Scarborough Shoal. They seized Scarborough Shoal in 2012. So we have to be very careful because the code of conduct could legitimize China's island building.
Sir, do you have a time frame for that? China taking over Scarborough, building an island there?
Well, we know that they've almost started in 2016, early 2016. And when are they going to try it again? I think they will do it in the next 3 years, before the end of the term of President Duterte.
You will do it.
Yes, that's their timetable, because they said we will sign a code of conduct in 3 years' time, 3 years from now. So they should be signing after they have completed their air and naval base. Means they will do the reclamation within the next 3 years, just before they sign the code of conduct. Independence goes to the very core of being a judge. A judge has to be impartial. And to be impartial, you must be your own man. You must be independent.
Sir, was it wise to set aside, or the President Duterte used the word ignore, the arbitral ruling in favor of the oil exploration agreement?
Of course, we should not ignore the ruling in favor of any agreement. I think that has been clarified. We are not setting aside the ruling. We're not ignoring the ruling. The ruling stays there, and we are in fact preserving the ruling because the MOU and the TOR does not in any way waive our sovereign rights over our EEZ. It preserves our sovereign rights, and that's why I'm in favor of that MOU and TOR, provided we stay within those parameters. China will come in as a part of the service contractor, either as an equity holder or as a subcontractor or a service contractor. That would be fine. So we are not ignoring the ruling because we are protecting our sovereign rights under the MOU and the TOR.
Sir, what do you think about the composition of the steering committee? I think the names have been recently released.
Well, it's balanced because they have their members, we have our members, they're high-level people, and I think they're going to meet this November. I hope they can come out with the rules so that the working group, which will be composed of the commercial enterprises, Forum Energy and Sinuk, China National Offshore Company, can agree on the commercial terms so that they can proceed.
Sir, where do you think China agreed to the 60-40 sharing?
Well, I think because of the ruling. With the ruling, no country in the South China Sea, Vietnam, Malaysia, Brunei, Indonesia, and the Philippines can give up sovereign rights anymore because international law has clearly laid down the rule. You have sovereign rights. And the people of these countries know that international law has affirmed their sovereign rights. So no government can give up sovereign rights because they will be ousted by their own people. So China, I think, has realized this. So China has recalibrated its position by getting part of the income, but they will have to work for it. They will have to provide services. They will be receiving compensation for their services.
Sir, former Foreign Affairs Secretary Del Rosario and Ombudsman Conchita Carpio Morales filed a communication before the ICC against Chinese officials. Sir, will you join them as part of the legal team or some other capacity?
Well, that's under consideration, but I will have to decide that after I retire.
Sir, what do you think about the, I think a House resolution in the U.S. Barring Philippine officials or any officials for supposedly supporting the persecution of Laila de Lima?
Well, to that question, I will just state the principle under international law. Every sovereign state has the absolute right to decide who can enter their territory who are not their citizens. They have the absolute right to bar foreigners for whatever reason. So that's the premise. So with that, we cannot complain if, for example, Australia will bar our citizens from going. But of course, we can retaliate, do the same to them, and they cannot complain also if we retaliate. So the principle is, if you're a sovereign state, you can bar for any reason foreigners from entering your country. That's the basic principle.
And you can question it. It's up to them to do it.
Yeah, you cannot question it. The only way you can do is, if you are a sovereign state also, is to
Do the same
retaliate.
thing. And sir, in the coming days, I think within this week, I think the president will name his next chief justice. Sir, what are the qualities that should the president consider? CJ Bersamin said that it should be more EQ than IQ. What do you think about it?
Well, I've always said that the number one qualification should be independence. Of course, that assumes that you have the competence, intellectual competence, because independence goes to the very core of being a judge. A judge has to be impartial. And to be impartial, you must be your own man. You must be independent.
And sir, by the end of the year, the Supreme Court will be composed of 11 Duterte appointees. Sir, talking about independence, what do you think about that?
Well, that's the way it happens. That's an accident of history, because he is the president at a time when there are vacancies. Maybe that should teach us a lesson that members of the Supreme Court, maybe when we rewrite the Constitution at a future time, like in some countries, members of the Supreme Court, a third will be appointed by the president, a third by the parliament or the legislature, and a third by the Supreme Court itself, so that no one man can appoint everyone. Maybe that should be the lesson from this circumstance in history, where one person will be appointing about 12 of the members of the court. But that's in the Constitution. You cannot question that. The only thing you can do about that is to profit from it and learn from it and use that to improve the Constitution next time.
But sir, with that composition, don't you think independence will be compromised? Especially this year, by the end of the year, there will be a possible extension of martial law. War on drugs is still on the table.
Well, it depends really on the justices themselves, because they are free to decide cases.
All right. Thank you, Chief, and happy retirement.
Thank you also, Anjo.